we've structured today's webinar is that we won't have a long drawn out presentation by Sylvans. We'll break it into several parts, which gives you time to ask questions and then he responds, so that we don't wait until the end of the presentation to take questions. We want to be able to ensure that we meet your every need today in this webinar. So Sylvans, you already are familiar with his bio because it was part of what we sent out with the registration link. Yes. So I will now hand over to him to begin the presentation on intellectual property rights with a focus on knowledge assets in academia and IP rights protection. Thank you.
Thank you very much, Helen. I would want, first of all, to take this opportunity to thank USIU Africa for arranging for this workshop, despite the challenges that have been posed by COVID-19 pandemic. I also want to acknowledge and appreciate those who registered to be part of this workshop and are also ready to listen. As the topic has been mentioned, I'm going to talk about knowledge assets in academia and intellectual property protection. The reason why I find this topic very, very critical in this kind of environment is that in an academic institution, from the earliest door opened in the morning to the latest one closed in the evening, business is about knowledge. It is knowledge that is created, it's knowledge that is imparted, it's knowledge that is transferred from one point to another. So in this case, I would want to give emphasis to the knowledge that is created. We all know that when it comes to knowledge that is imparted, that is when it goes up to when students graduate and get empowered to do all that pertains to that degree. But when it comes to knowledge that is created, in most cases, you find that this is not one that is also engaged to the extent that it can benefit the institution. When we are talking about knowledge assets, we are talking about knowledge that exists in form of tangible and intangible. Tangible knowledge in this case, we'll talk about biological materials that are created in laboratories, but knowledge-based assets that are intangible also exist as elements of intellectual property and non-intellectual property. So you can see we've scaled down, rather we've moved, we've descended from knowledge that is tangible to knowledge that is intangible. And then we go to the intangible aspect of the knowledge, where we are talking about those that are of intellectual property nature and those that are not of intellectual property nature. The good thing is that all these arise in a university environment. Now, when it comes to knowledge that is intangible, or rather knowledge that is intangible, and we have intellectual property, there are quite a number of aspects of IP that arise in this case. And we are going to see each one of them as we go down, because as you've seen, we are talking about knowledge assets in academia, but we are going to give more emphasis on intellectual property protection. Now, I would want to go down to the word intellectual property before I go to the aspects of this that are created in an academic environment, and say that intellectual property, basically, it is the product of the human mental creation or process. It arises from human mind or intellect. Intellectual property largely exists in two categories. The first category is referred to as industrial property. The second category is copyright. Again, this is important to note because they'll lead us to the various aspects of intellectual property, and as they'll be available to protect these knowledge-based assets that you're talking about in academia. When it comes to characteristics of intellectual property, which is very important that we also talk about them at this point in time. Basically, intellectual property is an intangible form of property, as we categorized initially. It's an intangible form of property, and it means that it's not something that you can see, something that you can touch, something that you can feel, but importantly, is something that you can detect. Usually, I give an example of an intangible property of mobile phone network. Mobile phone network is such an intangible property because it's one that you cannot touch, you cannot see, you cannot feel it, but you can detect it by use of your mobile phone handset. So that is one important characteristic of intellectual property. The second characteristic of intellectual property is that it's a personal property. This is very, very important. And that property, that characteristic does not need to be expounded on much. If you go to the definition of intellectual property, which talks about it being a creation of human mind or intellect. The word human is very important because it means that if somebody, if one is not a human being, probably we cannot talk about creation of intellectual property. Intellectual property is a simple form of property to create, which in order to come up with it, you only need your brain. You don't need anything else, not even going to school. And if you generate one as a result of going to school, is only but an added advantage. This is another very, very important characteristic of intellectual property, which shows that every human being has the capability of coming up with this property. And the word intellectual forming part of it, it is not with respect to the extent somebody has gone to school. So that is an important point to note. The fourth characteristic and the last one, or rather second last, is that intellectual property is based on information. And this is a very, very important point to underscore, because if indeed it says that information is power, and intellectual property being based on information, we can easily say that intellectual property is power. When we are talking about the era in which we are in, is the era of information age. It would be defined as one where ideas and information have gone ahead of manufactured goods and agricultural produce as key commodities. If you want to count the tools in trade at the moment, you will talk about mobile phone network. You'll talk about webinar that we are now using. You'll talk about internet. You'll talk about software. You'll talk about websites, movies. All these are the tools or the commodities that are running the GDPs of the contemporary economies. Here in Kenya, a good example is if you consider which business here in the country that is earning our government the maximum amount of tax, obviously you'll find that is a service provider in the area of mobile phone and mobile money transfer. Before this era of information age, it used to be, here in Kenya, it used to be a company that the business is based on material goods. So if you look at the service provider in this area of mobile technology, for example, Safaricom, and then you also look at the business that is based on material goods like EABL, then you can compare the GDP of the two, or rather the turnover of the two, and find to how much amount of tax does each pay to the government to confirm that actually the GDP at the moment is largely depending on conceptual aspect as opposed to material. So this is something very important for us to note, because when it comes to intangible knowledge, the price of the commodity is not as fixed as a tangible property. If you look at, for example, the mobile phone network, which you can access by buying a scratch card, you will get a scratch card maybe for, at one point it was 5 bob, which was found not to be economical. And then it was moved to, I think the lowest, I think, is 20 shillings. But again, in as much as that exists, nobody confirms to you that at an amount of 20 shillings, the network that you'll receive as a result of buying that scratch card will be commensurate to the access that you have. So again, here you'll see one thing, that when it comes to intangible assets, it's a matter of the willing seller, the willing buyer, because in any case, you find that the amount of access you get is less than 20 bob, then definitely you'll not have a ready answer as of whether to decide to buy it or not. The last characteristic that I would want to mention here is protection of intellectual property is territorial. And I think that's another very important characteristic to underscore. It depends on the jurisdiction of where you would want it to be protected. We don't have kind of boundaryless protection where you just get rights that are all over the world. So protection of intellectual property is territorial. Now, in order to now move to the aspects of intellectual property, I would want to give it a very, very simple entry, in the sense that the aspects of intellectual property range from inventions, designs, trade and service marks, and copyright. Now, if you look at those that I've mentioned, they arise from activities that are carried out in academia almost on daily basis. Because if you look at, for example, patentable invention. Patentable invention is something that arises from research that is conducted in a university. It arises from use of facilities by faculty and staff. it also arises from student coursework. When it comes to creating this kind of assets, everybody in the campus will be eligible for this, even if somebody is not necessarily a student. Why? Because everyone has got a brain, as we said. When it comes to non-patentable, whereby we have non-patentable inventions where we have know-how, again, you'll find that these are information that are coming from the results that are maintained in notebooks, experiments, recipes, and cocktails. Now, you realize that we have patentable invention and non-patentable invention. So here, when we talk about the assets, first of all, we look at them in a broad way, and then we'll narrow down to those that are subjects of intellectual property. When you look at the aspects of copyright in a university environment, you will find that these are divided into the academic work, which is non-artistic, and then the artistic work. And the academic work, where copyright arises, include course materials, research reports, lab notebooks, student coursework, thesis, computer programs, and web pages. All these are literary works. Then we have the artistic works, where we have things like video, we have film, we have sculpture, we have musical works, and broadcasting, and so forth. So these are things that are not new in an academia, because are things to do with day-to-day activities that are taking place in that environment. We also have aspects of trademarks that also arise in that environment, from that environment. And these are like products that are developed on campus. We have institutions that also produce products, and therefore, as a result of that, there is need for trademarks also to to exist. We have logos like the USIU logo, computer programs that are created in campus would also need the identifiers in form of a trademark. Courses and learning systems are also things that can also be given symbols that can identify them as trademarks. When it comes to computer programs, which are still subjects of copyright, we find that they are created out of research that is done at the universities, teaching, student coursework, administration, and hacking. Hacking in the positive way. It's not that as of stealing somebody's work. That access that can lead to creation of original and new work that belongs to the author. We also have other forms of non-IP assets like databases, where it's basically a collection of information. When we talk about copyright, we'll be emphasizing on creation of a new and original work. New and original work. So if something is not new and original, it's just a matter of it being put together, that one might not per se form an aspect of intellectual property as copyright, but it will still be an intangible asset existing in academia that would require to be handled in a certain way. A good example is that here in Kenya, we now have Data Protection Act. And again now, having this act in place, and yet we have a Copyright Act, will give that clear difference as of copyright not protecting mere collection of information. And this information in a university environment is derived from research, general conduct of businesses, academic inquiry, and course materials. I started by talking about tangible and intangible knowledge assets. And I talked about tangible research property, which constitute biological material, things that arise from laboratory research, but they are of tangible nature, and they also hold some commercial value, which means that they also need to be transacted as assets. These biological material include things like cell lines, organisms, proteins, plasmids, DNA, RNA. DNA is just a deoxyribonucleic acid, and RNA is ribonucleic acid, transgenic animals, and etc. So again, these are things that arise from research. Given that they are not aspects of intellectual property, would need that if they are supposed to be transacted, then we have things like material transfer agreements that are supposed to be in place in order to handle this. When it comes to information that is generally released to public, you will find some aspects of it that could also be of protectable nature, but there are ones that are not falling among all the aspects that we've talked about. And here is where we talk about things like trade secrets, something that just need to be kept away from others, but in a legal manner. It's not just in an ordinary way. So a trade secret here in that environment also comes from research, computer code development. The only challenge about this is that if the institution is a public one that is supposed to share the information with the public, who are the taxpayers, then how does it happen as opposed to a private institution which has got all the rights of keeping it as trade secret and then can transact it? And again, the challenge about this is that if it is something that arises from the research that is done by people in the laboratory, and then the university here is the one that would be associating with it as the body that is supposed to have it, then, or rather the body that's supposed to own it, then how does it happen here? Because a trade secret, you have to keep it secret. So with, for example, students who will one time leave the university and go elsewhere, and they are the ones who came up with it and it's a trade secret, then what happens? So largely it has been found that among the intellectual property aspects that is challenging for an academia to appropriate well is trade secrets. Now, up to that point, I think I would wish to give an opportunity for any need for clarification before I talk about how to protect the intellectual property.
Yeah, so thank you very much, Sylvans, for that a very great introduction. I have two questions that have come in, and they have come from Jonah Rao, and they relate to something that I actually was hoping that you would delve into a little bit more, data. Okay.
Data.
So his first question is, at what point does data collected by a student become the intellectual property of the university? And Then the second question is, what valuation models back up a price on IP?
Valuation model.
Valuation models back up a price on IP. And my own question there was really whether data itself is considered IP, based on the fact that you talked about, protection of IP being territorial depends on jurisdiction. So for instance, in the American context, maybe data is not considered IP, yeah.
Thank you. I think about the data, I mentioned that we have IP assets and non-IP assets. And I talked about databases being a subject of what is not protected as IP because it's just collection of information. And I've given a good example here that we have a law on data protection, which again, if this were to be a subject of intellectual property, then copyright and any other law that protects intellectual property could have come in to do that. So when it comes to copyright, let us look at it that copyright does not protect an idea. It protects the expression of an idea. And this expression of an idea has to be, one, it has to be new, two, it has to be original. So these are the requirements for a copyright to exist. It has to be new and it has to be original. So when we talk about just putting information together or other data together, then that one you can see like the originality might be lacking because the basis for which that one is done does not input that kind of the labor intention, or rather intensiveness. So when it comes to valuation model, intellectual property valuation is a special area of study. And again, you will find that it depends on the aspect of IP that needs to be evaluated. Generally, there is a scope that says that intellectual property can be evaluated using certain methods of the market approach, the income approach, or the cost approach. That is the general scope of evaluating intellectual property, but the actual doing it is something very specific that will really depend on that aspect of intellectual property. For example, if you come up with a process of purifying mineral water, we know that we have different brands of mineral water, but this one now is a process of purifying mineral water. And when we talk about an invention that is patentable, we talk about a product or a process. So here is a process. When you are to value that, definitely you can go by considering the market approach, if at all the product has been taken to the market, or the cost approach where you compare it with the products that are already existing and how much they go for with respect to the qualities that you think you've brought in newly that are not in those ones that are already selling at certain prices, or even the market approach. So that's what I would say for this, but again, it is an area that can stand alone when it comes to talking about intellectual property.
Thank you. There is one more question, and really somebody, Imelda wants you to clarify on tangible and intangible assets. And before you respond, Sylvans, this goes out to the participants. Please type your questions in the Q&A because we are not really concentrating on the chat. So if you could have your questions typed in the Q&A area, it will be easier for us to pick them and then we'll be able to respond. I see some questions that relate to If you are employed by the university, then create code that isn't necessarily for use in your department. Who owns the IP? Each university has an intellectual property rights policy, and it sets out, the type of guidelines in terms of who owns the IP. If there's substantial use of university resources, then in most cases you will find that the university will own that IP. Okay, over to you, Silva.
So tangible and intangible.
Yes.
Yes, I talked about knowledge assets that are divided into tangible and intangible. And when it comes to intangible, I talked about aspects of intellectual property. And there are also some intangible knowledge or assets that are not part of intellectual property. And here, when it comes to intangible knowledge that are not part of intellectual property, I mentioned databases and I mentioned know-how. But when it comes to tangible property, we have like biological materials that are created in the laboratory, which are referred to as tangible property. The cells, plasmids, and proteins, the ones that I talked about. These are assets in the sense that if somebody would want to advance in that area of research, would come to where this material exists and then acquire it. And for that matter, I was saying that if it is not intangible properties, a tangible one, it needs to have another way of handling it. And that's when I mentioned things like material transfer agreements that can be put in place in order to afford that. And again, as we just mentioned, the issue of policy, that's where now the policy will come in to clarify how such property is going to be appropriated if it becomes something that has arisen from the university, and therefore it has some commercial value that needs to be transacted. I think the second one, you've answered it. The second one, I think you've answered it.
I answered the second question because you see.
Yes, but I think what is important there is that basically, as we talked about the characteristics of intellectual property,
yes,
intellectual property is personal property. So the first person to claim ownership or to claim ownership to it is that individual whose brain has contributed to creating it.
Yes.
You will find that a university is a legal person which does not have a brain per se, but the brain of that legal person is out of the brains of the people that are in that environment.
Yes, exactly.
So usually it is deemed that this property being a private property, a personal property, it belongs to that person who has created it. However, if the environment in which it's created involves some intervention or contribution by the institution that the person is in, then the policy will come in to state how this kind of property would move from this individual person to the institution.
Yeah.
And in a situation like that, sorry, Ellen, in a situation like that, Sylvans, what can you say about works made for hire? Because you've talked about, Helen has mentioned, for example, the university has resources that an employee or a student can make use of throughout or during maybe the research or the development of such assets. But I'm curious as to what you would say in terms of works made for hire. So say maybe this student has, I see Wilfred Kidula has mentioned something like that. An employee working at, for example, a university has created something, but is not being used by the university. And maybe they leave employment, and then that particular asset becomes viable. How would that kind of navigate, and what can you say about works made for hire?
Yeah, I think the question is broad. Let's start with work for hire. That one is as direct as the statement puts it, because if somebody is hired for purposes of creating information of that nature, for example, in area of copyright where we mostly we have work for hire, you will find that there is something that will go to the master as a result of hiring this person to do that work. But again, let us not forget, as what you say, that it's a personal property. There is that moral right to remain that person who was hired to do the work. There are certain rights like the commercial rights and whatever that will go to the person who hired this person to do the work. But the fact that that work has to specify that this was done by so and so, that one is something that has to remain with the person who has created it. When somebody creates work which is not for hire per se, but in an environment like a university, where some facilities of the university have also been used, known to the person who is creating this work, then again, the policy comes in to spell it out so well. But otherwise, these are what we at times talk about as technovation. Technovation is where you've come up with something, even if you are in that environment, but this something is not part of what you are hired to do. And then the employer finds it useful that would want to use it. Then this is where we go the technovation way. You will be recognized for that, and then you'll be given the technovation certificate, which the IP office will have to record it in the register. And when it comes to, for example, I would want to take in the area of research. If we look at a place like Cambridge, we have a certain cadre of staff referred to as researchers. They are employed to research and give results. So this is where, even if you are talking about work for hire, is a different thing altogether, because this person is on monthly salary, and the purpose for the person to be there is to research and produce research results. So to the extent that these research results could end up having aspects of intellectual property, including inventions, then you can see those are just outcomes that can measure the excellence of this person as a researcher, which could lead to promotion and rewarding and whatever as per the policy. But again, the first starting point is that this person has been engaged as a researcher. I think that's also another very important point to capture. It depends on what you are engaged to do, out of which the consideration is the monthly salary that you are getting and all that goes with it.
Yeah.
Yes. Okay. Susan, are you satisfied with that response?
Yes, yes.
Okay. So Sylvans, two more questions.
Yes.
Wanjiku Geshashi Muhammad asks, are trade secrets registrable? If yes, what is the process of registration? And then there is a question from Wilkista Simiu. Does selling of agricultural products like seed originating from another country amount to infringement of intellectual property of that company locally, when in fact the IP is developed elsewhere? And then I have a question here, which even though we have a session, a webinar that will be strictly dedicated to entertainment law, I thought I should just pose it to you because it has a component of IP in it. So Samuel Akwale asks that you comment on the following. One, protection and compensation for IP of presenters in online courses offered by an institution. And then number two, the explosion of artists seeking followers on social media handles. He says he met a young man who is keen, not so much on producing quality music, but just to get up to 1,000 followers so that one can even buy followers.
So let me start with the one on seeds. When it comes to seeds, new plants and seed varieties, you'll find that these per se are not aspects of intellectual property. These are what we refer to as protection sui generis. And in that sense, you'll find that here, even here in Kenya, when we talk about the categories of intellectual property, as I mentioned, I talked about industrial property as well as copyright. I mentioned protection of new plants and seed varieties. So this one becomes another subject of protection. And here in Kenya, we do have seeds and plant varieties protection, which is done by KEFIS, as we all know. But these are what we refer to as protection sui generis, because you realize that an aspect of intellectual property has to do with the mental labor or intellect. But it's found that a number of what happens in seeds and new plant varieties are subject to biological processes largely. So again, I would rather that if that question is to be answered very well, then there is need to engage an institution like KEFIS, that's Kenya Plant Health Inspectorate Service, to elaborate on this and many more along this area. Trade secret is not protectable, or rather are not protected. There's no formal way of protecting it. Trade secret is simply keeping that idea secret. And that secret is supposed to be a legal secret, not just lifting a pillow, for example, and place it under the pillow and then you rest your head on it. The difference between a trade secret and a protected IP is that protected IP will end up being disclosed to the public when it is published. But a trade secret will not be published as such. There are so many ways of keeping it secret. But the problem is that the way somebody came up with it is very possible and natural that somebody else can also come up with it. That marks the end of trade secret. When somebody comes up with it, you cannot claim that that person is infringing yours because you kept it secret. How did this person access what you had otherwise kept as a secret? Examples that but for India,
we can't hear you, Sylvans.
There's a drink, if you go to India, there is a drink which is similar to Coca-Cola. They call it thumbs up. So if you go there and very quickly you order for Coca-Cola, they'll intervene and tell you that we have something similar, which is called thumbs up. But you see now Coca-Cola cannot challenge that one because these people, through their reverse engineering, if they came up with now what they are calling thumbs up, even if the recipe and whatever the formula is the same, then please note that you kept your secret. So who could have made any other person know it? So I think that one could be sufficient for that question on trade secret. These other questions are really largely copyright. These questions from Samuel are really largely copyright. When it comes to compensation and the protection of these presenters, yeah, but I would think that probably these ones would be very good questions on the side of copyright, of which probably I may not have authoritative answers as such to this one.
Yes, we will actually have a session that's for Sam Akwale and the rest of the participants. We have another session hot on the heels of this one on entertainment law. And
yes, I think that will be very relevant opportunity to answer this.
Yes. Now there is a question from Liz Guya. If someone has created a digital magazine, can it be copyrighted? It's an original work. it's an original work of the person and related participants.
Yeah. In fact, what I said is that copyright is expression of an idea, and that idea has to be new and original. So if that word original exists and the person can justify that originality, then it's good, it can exist, because with copyright, the protection has got that kind of, I would not say good faith, okay, it has good faith coexistence. So long as you've not copied from another person, you've come up with it yourself, it can enjoy copyright just like any other that's existing.
Okay, thank you.
And the clear point there is that it's original.
Yes.
A copyrightable work has to be new and original.
Okay, thank you. Now, there's a question from Martin Joroge. I believe that's Professor Martin Joroge from USIU Africa. Does IP infringement always give rise to criminal liability? What is the rest of the question? Yeah, I know that you can actually pursue a civil action for IP infringement. So I guess in that, I'm also answering the question. What other avenues are available?
Yes. You see, IP, intellectual property, as we said, they are personal property.
Yes.
And therefore, issues of infringement. And you see, we are talking about rights here that are of commercial nature.
Yes.
So in as much as now the infringement can go criminal, these are now where we are talking about willful infringement.
Yes.
Whereby somebody deliberately is just doing something, knowing very well that he or she is infringing. Just like where we are talking about issues of counterfeiting.
Yes.
That is where you can find that kind of willful act. Somebody is just doing it deliberately, knowing that this is what I'm doing. And that is the intention or objective of what the person is doing.
Yes. So Professor Martin Joroge, I believe we have answered your question. I see a couple of other questions, but I want to now give you an opportunity to continue with the presentation, and we'll pick some of these questions for the next round of questions. Thank you very much for those responses.
Okay, welcome. So let me go to the next session of this presentation, and therefore I wanted to talk about protection. Before I talk about protection, I wanted to revisit an issue that I mentioned when it comes to intellectual property being an intangible property, which you cannot touch, you can't see, you can't feel, but you can detect. You'll find that if some work is taking place in the laboratory, maybe for purposes of arriving at some solution that is of need, there are things that can guide into finding out whether that outcome has got some inventive potential. And here I would want to look at what an invention is. An invention is basically a solution in form of a product or a process to a specific problem in the field of technology. A solution in form of a product or a process to a specific problem in the field of technology. It's just like a technical solution to a specific problem. Now, in a laboratory environment, you might find that the solution that you are having to a problem that you are solving has, for example, improved performance. If performance has been improved, which means that whatever you are trying to address is the issue of improvement of performance, then those are indicators that could send the likelihood that an inventive step could have been struck. If the time to market is reduced, maybe something works at a longer time, that you've come up with a way of making it generate the same outcome but at a shorter time. When a solution is more cost effective, which means that whatever you've come up with is cheaper than what has been existing. A good example that impressed me on this is the people who have come up with they call it ventilator. The innovated ventilators. Innovated ventilators. And you'll find that one main thing that they are addressing here is that it's a cheaper one compared to the ones that the government is really planning with heavy resources to bring forth. So again, that is one indication that there could be likelihood of an invention. The customer demand for the product has increased significantly. That demand also indicates a likelihood of something new that has been created. When new independent pieces are put together, that one we can't overemphasize on, because you find that at one point, US really existing, that the technology advanced in a way that just one device can bring in all sorts of things that were otherwise independently existing. When a problem has been identified and solved, size is reduced. You remember that when size is reduced, is an example where with the invention of computers, for example, hard drive used to be as big as a whole story building. But further innovations made it possible that now the hard drive of such a is a very, very small piece of a thing.
There's a problem with your audio.
Yeah.
Hello?
You're
There's
kind
a
of
problem
breaking.
with your audio.
Is it okay now?
Yes, now it's okay.
Oh, okay. So I was just explaining an outcome where size of something has been reduced, as opposed to probably the original size that used to be if it was not convenient. And I'm saying that the invention of computer was one with the hard drive that was as huge as maybe the size of a story building. But further interventions made it possible that you can find the same memory storage that used to be of that big size has been reduced to something very small. Longevity of the product is increased. The product is more durable than what has been there. New functionality has been added. Again, that's another very interesting way of finding out whether an inventive step has been arrived at. The cycle time is reduced. So the reason why I'm sharing this is that in a laboratory environment, all the research work that is done surrounds any of these that are being looked for. And therefore, any of these indications could indicate the likelihood of an invention having been conceived. So it's really very important for us to appreciate this and find that, and learn that inventions are not things that are in a different planet. They are just within us, the way we live and we do things. I would go to protection of intellectual property. We have those that are subject of protection and those that are not subject of protection. For example, when we talk about a discovery, scientific theory, mathematical methods, those ones might not be subject of protection by way of patents. When we talk about what is not protectable, let us understand clearly as of it is not protectable by an aspect of intellectual property or is not protectable as a whole. There are those things that we say that they are not protectable as aspects of intellectual property. But again, we talk about what is not protectable by patents because it's protected by copyright or is protected as a trademark, or is protected as sui generis. So all those things that are the things that we need to consider. Now, in order for me to talk about this protection, let me talk about the instruments that provide for this protection. At international level, we find that we have two very important instruments for protection of intellectual property. And the first one is the Paris Convention for the Protection of Intellectual Property. And the second one is the Berne Convention for the Protection of Literary and Artistic Works. To add on to that, I would say that we also have one that is called Trade-Related Aspects of Intellectual Property Rights, TRIPS, that has also joined these two as also an instrument at international level for protection of intellectual property. There are so many other instruments, but I would want to limit to that for this purpose. You'll find that at regional level, that's at international level, at regional level, we have also instruments that are for protection of intellectual property. For English-speaking countries of Africa, for example, we have Harare Protocol for the protection of intellectual property. And we also have the Banjul Protocol for the protection of, or rather, for the protection of trademarks. That is among English-speaking countries. We also have similar protections for French-speaking countries, but that one will not take on board now, given that now we are in an English-speaking country. When it comes to the national level, we start from our Constitution, 2010, which has provided very well for protection, supporting, and promotion of intellectual property rights. And again, all the times I get an opportunity, I've always said that Kenya is one of the countries in the world that has got a very good constitution when it comes to matters of intellectual property, because it has elevated IP intellectual property to that level. And it has provided specifically, actually, just going by the face value of it, the word intellectual property in that constitution is mentioned 5 times. And being the document of the nature that we know, concentrating on IP that much, it shows that a good emphasis is there. From the constitution, then we do have a number of legislations that are for protection of industrial property, intellectual property. We do have the Industrial Property Act of 2001, which created the IP office, Kenya Industrial Property Institute. And it has a regulation implementing it of 2002. We do have Trademarks Act of 1956. Again, also administered by the Kenya Industrial Property Institute. We have the Copyright Act of 2001, implemented, the one that has also created the Kenya Copyright Board to deal with matters of protecting copyright. And it also has a regulation of 2005. Here in Kenya, we also have another institution that deals with aspects of intellectual property when it comes to enforcement. It used to be called Anti-Counterfeit Agency, established by Anti-Counterfeit Act of 2008, and also implemented by regulation of 2010. This is the one that deals with the enforcement of IP. We also have in the Industrial Property Act, we have Industrial Property Tribunal, which also has the role of checking on what the managing director, the decisions made by managing director on matters, patents and industrial designs. And again, in the Copyright Act, we also have there is a body there that is also meant to arbitrate matters copyright. Forgotten the name. Now, when it comes to protecting this kind of property, we have all those instruments I've mentioned, as well as the institutions that are supposed to do them. And therefore, it's just now a question of apportioning these aspects of intellectual property, as I was mentioning earlier. If an idea is functional, then you can consider having it as a patentable invention. If it's just a symbol that is supposed to be used in business, a business symbol for that matter, in form of a trademark, then you can also have that get registered at the Kenya Industrial Property Institute. When it comes to copyright, under the Berne Convention, it's provided that protection of copyright is based on non-formality. And these are the rights that we really need to understand very well, because when we are talking about the need to identify and benefit from IP aspects that you may already own, then we have to look at that of copyright, because it is rights that automatically kicks in when you have that idea, that when you express that idea in a tangible form. And as I said, it is not the idea, it is the expression of idea as a subject of copyright protection. So here in Kenya, there is a small procedure that has been created by Kenya Copyright Board. Even if protection of copyright is based on non-formality, there is some kind of an acknowledgement document. I would not call it a certificate per se, but acknowledgement document that will actually prove that you are claiming to be the author of that particular work as at the time that you file it with the Kenya Copyright Board. So it is slightly different. It is different from what happens at the Kenya Industrial Property Institute, where you need to express a wish or a feeling of registering such work. It is not something that can just be taken to be existing automatically. When it comes to the matters to do with the trademark, again, a trademark here, you'll find that it's a symbol that is used in connection on or in connection with identifying and distinguishing goods of one person from those of others. And again, the right that is underlying here is not basically that one to come up with that figurative element or the word. It is the use. When this symbol is put in use is when the rights over trademarks are created. You will find that if you look at the Trademarks Act, there is a definition of what is a mark and then what is a trademark. That is very, very critical. There's a definition of what is a mark and what is a trademark. A mark can be a symbol that can be entered into the register for purposes of making it a trademark within a certain period of time. And therefore, not all symbols as they are would be referred to or qualified to be referred to as a trademark, because in the same act, there is a provision whereby if there is non-use of that symbol for a constant period of 5 years, then even if the institute has not removed that registration from the register due to non-use, any third party can come and claim that this trademark has been registered here and it has not been used for all this period, and therefore it could be standing on the way of mine that is similar or identical that I wanted to register. The gist of that is that the Trademarks Act does not encourage what is called trademark banking or warehousing. Any symbol that you register, you must do it for the purposes of making it serve as a trademark. And a mark serves as a trademark when it is presented before the consumers outside there to use it on or in connection with identifying and distinguishing goods of one person from those of others. I've spoken quite much. I don't know whether that one would be sufficient for me again to listen to interventions, because when it comes to matters protection, they could be wider than what I would be expected to say.
Okay. So the body that you couldn't remember the name, the competent tribunal.
Yes.
I see we have Miss June Gashui in attendance. And she has, yes, thank you, June. It's a pleasure to have you.
I almost talked about the competent, but then since
yes,
I was not very sure, I didn't want to.
Competent authority. Okay, so we have another set of questions, which I will ask my co-moderators, Salome and Susan, to please lead us in those questions. Salome, Susan?
Salome, do you want to go? Then I can handle the last set of.
Sure, that's okay. There's a question by David, by Alan Kariuki, asking, Kenya has a nuclear power and energy agency, but it is a functional and contributing member of the International Atomic Energy Agency. So possibly if you could clarify for us, what is Kenya focusing on in terms of the International Atomic Energy Agency and intellectual property rights within the body?
Okay.
Then there's another question by Alan Kariuki as well, asking a vaccine of inventive potential.
Sorry,
Salome.
I've lost you.
I'm saying Alan is
Yes.
also asking, are vaccines of inventive potential? It's a follow-up question on what he had asked earlier about what the country, Kenya, is focusing on in terms of IAEA and IP rights. Then the last one is by Kidula. Technology has been mentioned in the definition of an invention. Is there any legal definition of technology?
Okay.
I'll pause at that point and allow you to answer.
Thank you. The first question is an interesting one, asking for a link between IAEA, that is International Atomic Energy Agency, the nuclear body that here is in Kenya, and the intellectual property protection. Let me answer it.
Sorry, Sylvans, we lost you for a bit.
Hello?
Yes,
Is
now
it
we
okay
can
now?
hear you. Yes.
Yes. I was answering Alan's first question, which is bringing the nexus between the nuclear facility here in Kenya, the institution, what I know about International Atomic Energy is that...
Sylvans, we lost
Hello?
you. Yes.
Please adjust your mic.
Oh, okay. Hello?
Yes, now we can hear you. Yes.
Yes. When it comes to International Atomic Energy Agency, it is one of the specialized agencies of the UN. And that, whatever it's doing, be it in research or whatever, it is not as something that would end up being made as a activity. I'm happy to answer this question because in my profile, I mentioned International Atomic Energy Agency.
Sylvans?
Hello?
Possibly if you could just pause where you are and then you answer the question. We kind of lost you when you...
Hello? Are you getting me?
Yes, we can.
You are
And then
getting
also
me now.
try put the pod under, like on your chin, so that when you speak, there's the static. There's a bit of static when you speak into the pod. So just hold it under your chin, and then
Yes.
hopefully that's
Is it okay
better.
now?
Yes.
Yeah.
Is it okay?
Very clear. Yes.
Yeah, so I was saying that International Atomic Energy Agency is a UN agency, and that to subject of coincidentally, I was one International Atomic Energy Agency.
Okay.
As a fellow, and the research that I carried out under their sponsorship had got some innovative elements. I actually tried to find out from them whether this could be subject of protection as IP. And the response was the agency don't really look at protecting such outcomes. Rather, they would be things that are available for access by the public without protection. So when it comes to the body that it deals with the issues of nuclear technology here in the country, I would not see any aspect of intellectual property there, because at the end of the day, we are talking about just Kenya having nuclear energy as a source of power. And therefore, I would not at this point be in a position to link what it's doing with the aspects of intellectual property. But when it comes to the UN agency, that's International Atomic Energy Agency, which works with this, it's called Kenya Energy and Petroleum something, petroleum and nuclear energy something. When it comes to those functions, I think they are not really what intellectual property will really come in as something significant to share. Vaccine, yes, it depends on specific components of that vaccine, which would make it stand alone compared to what is already there, because we spoke about something patentable arises from a product or a process. And therefore, when it comes to things like vaccine, definitely you may end up talking about what they call the molecule, the active molecule that would make it serve as a vaccine. So I think that one is a subject, except if somebody wanted to talk about the method of treatment, which is not a subject of protection by patents here in Kenya as a matter of law. When it comes to technology, well, it's a scientific term, and I wonder if a legal definition would come. But for me, I know technology as a systematic knowledge for manufacture of a product or rendering of a service, systematic knowledge for the manufacture of a product or rendering of a service in industry, agriculture, or commerce. And is that technology must be destined to an end. It must be something portable from point A to point B, and it has to be a solution to a problem. So that is a definition that I would give to this technology, without minding whether it is it has a legal connotation in as far as it's concerned.
Okay, thank you so much for answering those questions. We'll take a set of 3 questions. One is by Kimberly Anindo, who is asking, how can child innovations be protected? Child innovations, yes. She's given an example. Recently, there was a boy who made a hand washing machine in Bungoma. So possibly you could explain in that context. There's an anonymous attendee who is asking, can you attach an email address or address to a symbol to be part and parcel of a mark or a trademark? Can an email or address be a symbol that is part of a mark or a trademark? And then the last question is by Wanjiku Gishashi Mohammed asking, where a trademark is registered in Kenya and not in use in the Kenyan mark, can the owner of the mark rely on use in other jurisdictions considering trademarks as territorial? Please expound.
Thank you for the questions. The email address being part of a trademark, it depends on how that email is expressed or presented. Because in a number of cases, people have tried to use the email address as what can be used to identify their goods or services as such. But you'll find that a trademark basically is a symbol. And this symbol, it means it can be a figurative element or it can be a word. And so long as it is capable of serving as a trademark, what does it mean? A symbol is capable of serving as a trademark, where if you consider directly or indirectly, it does not relate to the product or services that is supposed to be used on or in connection with, in terms of quality, ingredients, nature, or even purpose. That is when you will consider that symbol being capable of serving as a trademark, because a trademark is a symbol that is supposed to be used to identify goods. And therefore, for that matter, you cannot get something that has got not such capabilities to do so and make it as a trademark. For example, if you take a device or a symbol of an apple and you want to use it for a drink, for juice, for example, you might find that that distinctiveness will be lacking, as opposed to if you take the same picture or device of an apple and you put it on a computer. So that is the distinctiveness that is required, because that symbol for apple, for drinking, for juice, obviously is likely to describe or to preempt that this could be a drink that is made from apple and other fruits. But when you take that symbol and you put it on a computer, one thing that you are going to notice that there is no direct or indirect nexus between apple as a fruit and a computer. So you'll find that that is a very, very strong kind of a mark. And therefore, any symbol that has been used, like now the email address, has to have that capability of distinguishing. If it doesn't have, then it shows that it's a mark that has got no what is called essential elements to be registered as a trademark. When it comes to a trademark that can be existing in another country, and therefore the use there would be expected to be considered in a different country, it depends. Because, as I said, the concept of territoriality is basic to trademark law. It is until a symbol has been promoted, advertised, and marketed by the owner of the products to the consumer, such that the consumer get to know that this symbol identifies or distinguishes a brand or a product from those of others. And therefore, if that one has not happened in a territory, then that symbol cannot be called a trademark in a territory where the consumer has not associated it with a product or a service. So the concept of territoriality still stands in the sense that a mark that has been used in Uganda of a product that is probably generated there or exported from somewhere but is used in Uganda, where the consumers in Uganda would identify that mark with a product or a service in that territory, then that one will have the trademark rights. The same mark brought here and subjected to the consumer, Kenyan consumer, only to find that none of them can associate it with any product or a service, then that is not a trademark. It is a mark. And therefore, a mark is not necessarily a trademark. So here we are talking about trademark, business symbol. I hope I'm clear on that.
Yes, you are.
Yes. Yes.
There are two other questions from Yusuf and Dennis. Yusuf is asking, what is the difference between innovation and creativity? Dennis's question is, if I found new use for an existing piece of hardware by amending the design, is that new design enough to prove originality for patenting?
That one is, I think, is a software question. And I think, yes, so long as the word is new, as is mentioned, and the originality is drawn from the fact that he's done it himself. You know, the difference between a copyright and a patent is that a patent has no nothing like good faith.
We can't hear you.
Hello?
Yes,
hello?
Much better.
The difference between what I'm saying about the copyright is that it is based on originality and it being new. So whatever is mentioned enjoys copyright for as long as he's come up with it, no matter whether it's existing already or not, because you will find here it is not the concept, it's the expression of that concept. The difference between a copyright and a patent is that there is nothing like good faith invention. The novelty requirement in a patent would make it not patentable, even if you didn't know that it was existing in the farthest corner of the world. That one does not matter. But when it comes to copyright, you can find good faith coexistence where nobody copied from the other, but the two have to enjoy copyright because of the newness and originality. So I think that's how I can answer that question.
Yeah, and Yusuf asked, what is the difference between innovation and creativity?
Well, innovation largely reflects on the side of effecting that idea that has been created. But creativity is basically coming up with that idea. When we are talking about creativity and innovation, you will find that creativity relates much more to coming up with the idea. Then innovation is actually including implementation of that idea or making use of it. That's the simplest difference I could give in terms of innovation and creativity. And that's why at times we do refer to both innovation and creativity as different things.
There's, I'm seeing there's two other questions that were sent in by Perpetua and Martin. Martin is asking, would you advise engaging an attorney when patenting an innovation? And if yes, what role will the attorney play in the patenting process? And Perpetua's question is, with globalization and online trading, digital marketing, etc., is territoriality yes, of IP still relevant in entirety?
come up again?
Let me read.
That's a good one.
Yeah, read it again. With globalization and online trading, digital marketing, etc., is territoriality of IP still relevant in its entirety? So I'm guessing because of maybe because of just different like jurisdictions and just territories being in play, and what you mentioned at the beginning in terms of it being territorial.
Yes, yes.
Yeah, and as you answer that question, Sylvans, there's a question that somebody asked David Onyango.
Yes.
With so many Kenyans going into online content creation, what ways exist to protect our creations, e.g. on YouTube or other social media? Then he gave an example. When you host a program on YouTube, then a major media channel copies it, and whether that can be challenged. So I thought it would be good to answer those two questions, since you're going to deal with something on, territoriality and digital, the digital space, IP in the digital space, basically.
Okay. So when it comes to patenting and seeking legal advice, actually, this is very critical, because you'll find that when an invention is to be protected, there are two main aspects of that protection, or rather that document that would require to be filed for granting a patent. You will find that probably the invention is science-based in terms of coming up with it. But it being an intangible asset, as I said at the beginning, it needs to be perceived in a way that then it can be processed and end up with a protection by granting of a patent. And the intangibility bit of it will take it to the legal side. What I mean is that if an invention is to be filed for protection, there is that documentation that's going to be made. And preparing that document would require two aspects of it: the science bit of it and the law bit of it. Because the science bit of it will bring the understanding of the subject matter of that invention. But the law bit of it is the one that will safeguard if anybody would want to raise an element of an infringement or an infringement, or an element of invalidity. So it being an intangible form of property, the intangible aspect can only be interpreted and understood legally. But the origin of it, that one is science. So it's really important that unless this person is skilled enough to prepare what I refer as an application, patent application document, then it is very, very advisable that somebody considers a legal person who will ensure, among other things, that the subject matter is well covered and protected during the making of this patent document. When it comes to globalization and the online engagements, as has been mentioned here, you'll find that the intellectual property at one point was found that it cannot exist alone. It cannot exist solo. And that's why at one point there came another instrument for protecting intellectual property. The one that I mentioned as trade-related aspects of intellectual property rights. This one is an important instrument because if you look at it, it is not quite of a departure from the Paris Convention for the Protection of Industrial Property and the Berne Convention for the Protection of Literary and Artistic Works. But what it has done, in addition, it has increased trade rules in the background of intellectual property. So you might find that there are certain commodities existing in the market which are not entirely subject of intellectual property. But for them to transact in that global market, other aspects of trade have to come in. And that's why you'll find that here in Kenya, we have other authorities. One example here in Kenya, I would say Communications Authority, which is tasked with facilitating development of information, communication and technology sector, including broadcasting, telecommunications, multimedia, e-commerce, and postal and courier services. You will find that that body as a regulator has been given a role that would handle the aspects of these activities that you are saying here that are not specifically of intellectual property, because the ones that are specifically of intellectual property will have already been taken on board, even as this information is being loaded online for other use.
Okay. And just to let the participants know that at the next session, we will delve deeper into those issues surrounding IP in the digital space. Because I have noticed lately there's been a lot of concern from Kenyans of all walks of life on IP in the digital space.
In the digital space, yes.
Yes. Now, Sylvans, there is something you talked about in terms of the protections or the kind of focus Kenya has given to intellectual property rights. And I just have a general, like observation that I would like to make. Since you worked at KIPI, and you are obviously privy to the sort of innovations and kind of intellectual property that was being generated by Kenyans. Would you say on a scale of 1 to 10 that we have succeeded in protecting our IP? Sorry to put you on the spot.
No, it's fine. And I would answer it very simply that we have not succeeded, but we are succeeding. We are in the process of getting there.
So on a scale of 1 to 10, where are we? 5, 6?
I would say as Kenya or as Kenyans, because again, it depends. If it's Kenya, then as Kenya, I would put it at, because I would want to cover even the copyright, I would put it at 7.
At 7. And as Kenyans? And as Kenyans?
At Kenyans, let me put it at 5.
Okay. And then as universities, as institutions of higher education?
Some progress have been made, but if you compare the number of universities existing and the engagement that we've gotten from them, I would put it at 4. At 4,
okay.
Yes.
Thank you. I think we have 25 more minutes of your presentation and Q&A. And Susan, I believe, says there's 3 other questions.
Yeah, there's 3 other questions.
Yes, you want to take those, Susan?
Okay. So the questions are from Diane, Owa, and Dennis. Diane's question is, kindly clarify the differences between patent utility models and industrial design. Owa's question is, in the light of multidisciplinarity as advocated for in the academy, who ought to claim the patent for the product produced?
Multidisciplinarity?
In light of multidisciplinarity as advocated for in the academy, who ought to claim the patent for the product produced? And there's a question from Anne. What is the place of cultural expression in IP, and how can they be protected? Who would own these?
Cultural expression?
Yes, cultural. What is the place of cultural expression in IP, and how can these be protected? Who would own these expressions if they can be protected? And finally, as the fourth question from Dennis, if I found a new use for an existing piece of hardware by amending the design, is that new design enough to prove originality for patenting?
Okay. Thanks for the questions. The difference between a patent, a utility model, and industrial design is that protection by grant of a patent is based on an invention that has met the patentability requirements. Usually there are 3 of them. That is, it has to be new, it has to be non-obvious, and it has to be industrially applicable. So those are 3 requirements for an invention to be granted a patent. However, that same invention could happen that it is new, it's a bit obvious, but it's an industrially applicable. It's new, it's a bit obvious, but it is industrially applicable, or it's obvious. That is one invention that will be protected as utility model. What is common between the 2 is that both of them are protecting inventions, and both of them have a requirement of novelty, that is, it has to be new, and both of them are sharing the 3rd requirement, which is industrial applicability. However, the departure between a patent and utility model is that it does not need to be non-obvious for a utility model. And that's why at times utility model is referred to as petty patent or a lesser patent in terms of protection. It is a form of protection that is quite useful when it comes to countries that are developing, and therefore the level of innovation could not be that high, of which the outcome of such research could always lead to patentable invention in terms of the 3 applicable requirements. When it comes to an industrial design, which is also an aspect of industrial property, a design has to be something that you'll judge by just looking at it, visual, a shape that can attract your interest when it comes to making a choice to pick a product, not as a differentiator, but in terms of the outlook. What I mean here is that, for example, if you are going to buy a tablet is a generic device that is there, manufactured by so many companies, but as many as they are, you'll find that something unique about them is the appearance, the outward look. And that outward look, for it to qualify to be an industrial design, is not supposed to be functional. Again, that's very important. It's not supposed to be functional, because if it's functional, then that functionality should go for protection by patent or a utility model. So something that looks good before your eyes and can even contribute to you making judgment that out of all this, I like this one because of the shape. That is the understanding of industrial design. It's not functional. All the rest can function even without that shape. And therefore, this is something that is appealing to the eye. When it comes to multidisciplinary, yeah, this one I think is again something that a bit of it was mentioned earlier. It becomes a question of if that institution has got a policy that will spell out how such property can be appropriated in terms of maybe who should own it. But again, as I mentioned, that the first point of call is that individual who has come up with it. And then other considerations coming in, that's when the policy will come in to define, yes, we acknowledge you are the one who has come up with it. However, the environment with which you've come up with it has also been contributed to by the university or the institution, something like, and therefore the policy then comes in now to spell out how the benefits are supposed to be as a result of that. Because again, you know, thinking constructively is not something easy, and therefore, if it is not handled properly, it will be that people will be creating such like inventions and they fail to disclose because they want to benefit from it 100%, because the fact is clear that it was out of their mental intellect or mind that was created. But again, it has to be considered that the environment was also contributed to in terms of resource and facilities by the institution that the person is working. So I think that one is part of what had been answered, and that's how I can answer it again. When it comes to cultural expressions, here in Kenya, we have a law on protection of traditional knowledge and cultural expressions. That is an act of parliament that is supposed to provide protection to these aspects that are protection, that require protection sui generis. It is clear that this is not a subject of intellectual property, as intellectual property has been defined. And that's what I said, that if there is need, because of the competitive advantage or the commercial value, something is expressing or rather is exposing, and a protection is required, then there comes what we call protection sui generis. So here we have that act, which originally was created largely by its creation was coordinated by the Kenya Copyright Board. But as we speak now, this act has been given to the Ministry of Sports, is it Sports, Culture and Heritage or something like that?
Mm-hmm.
Yeah. That is now the ministry that has been given this act to roll it out, which may include even coming up with a specific authority that will be handling that, if at all it is not given to institutions like the National Museums of Kenya and so forth. When it comes to hardware, yes, hardware generally is patentable as opposed to software. But if something has come newly that is not obvious, then definitely that is something that enjoys its own protection as a patent. Or if not, then it will enjoy protection as utility model.
Okay.
Thank you,
Clear?
Sylvans.
Yeah.
We have 15 minutes left, and I thought we would dedicate those 15 minutes to, I see there's another question here from Rodney Malesi. What are your thoughts on Creative Commons licenses? Do they diminish returns for copyright holders, or they help in spreading ideas more. And there was a question from John Sande. John Sande's question had to do with, as a student of communication, if I take a photo using the university camera, who owns the copyright of the photo? And the next part of the question is, when I take photos during functions like graduations and use them, say, in newspaper articles or on my social media sites, who owns these photos? The camera person, the subject in the photo, or the publishing house? Again, as I said before, most of these issues will delve deeper into them when we are discussing entertainment law and copyright at the next session. But Sylvans, you can have a go at those questions.
I think particularly the one that has been asked by Rodney is a deep copyright question that I would like that if he doesn't mind, it could be kept for that particular time.
Okay.
But when it comes to those from Sunday, here is not a question of the camera and somebody claiming copyright because of copyright that arises because the person owns the camera. It is the taker of the photograph that will have the right to own those pictures, unless this person has been given the camera purposefully to go and take those photographs on behalf of the person who has given him or her the camera. So if the camera is just one that has been available, for example, in the department or in the university, and then the person takes it to go and take photographs, then those photographs, the originality and the newness belongs to the person who is taking the photographs. But if this is one person whose role includes going to take those photographs, good ones, and for use in other purposes on behalf of the person who has given the camera, then as you can see, it now borders, it goes to the side of work for hire. So again, now that one, you can see the moral rights will remain with the person, the photographer, but when it comes to other rights, then the person who had interest in sending him or her to go and take those photographs will also claim the economic rights underlying. So when it comes to the second question, it is still the person who takes the photograph. It is said that you can copy original, but you cannot copy a copy. What does it mean? If you walk in the streets of Kimathi Street, and there you see a statue of Dedan Kimathi, nobody will prevent you with your camera to take that photograph of statue of Dedan Kimathi. You can copy original. There's no infringement, but you cannot copy a copy. What happens is that after somebody has taken that photograph, it is now an infringement for you to copy the pictures of this person without the authority, because this person enjoys the copyright of the photograph that is made of the Dedan Kimathi. Go to the same place and do your pictures. Then that one will be good faith coexistence, even if the pictures look alike one to one. But the main thing here is, in either case, moral rights still belong to that person who photographed, even if the person was sent to do as if it's work for hire. And therefore, the person whose photograph has been taken cannot claim anything, because there's
maybe
because where you intend to use those photos in, your marketing brochures, for a commercial purpose, then the subject, you need consent.
And now that one, they call it image rights or something.
Image
like
release.
That. Yes.
Yeah.
That one becomes something.
A good example is in stock photography. So the photographer will submit his or her photos to the platform, and the photos are sold via license. So it's conditional upon the license. Now, the photographer is obligated to get release forms from adults, minors, whoever, a recognizable individual in the image. So in that scenario, the model has rights and therefore can claim, if permissions are not, the relevant permissions are not acquired by the photographer, then if the image appears in a, is used for commercial use, like in advertising and billboards and such, the model would have a claim. So in that context, as Helena said, the image release or the necessary liability release from the model would be required.
Yeah, I think you are right, because here is not just somebody who is taking photographs for purposes of not taking advantage of the person whose photograph is taken. That one is true, but if the photograph has something to do with the person whose photograph is taken, then definitely some consent, because I think these are what I call image rights.
Yes.
Some consent will be required. And even in trademarks, something similar exists. We have what is called personality trademarks, whereby you'd want to use a famous individual picture or name as a trademark. That one, the law requires that you seek consent from that person in order to do that, because otherwise, if anything happens to the product in the market that is having this person's name or picture, it will have a social effect on that person. And that person also has to know that if his picture or her picture that is used as a trademark or the name, there is a certain way that he or she has to conduct oneself, because some conduct can lead to the loss of business with respect to the goods or services that are used using this person's name. So there is that requirement that a consent has to be sought from this person to accept that I'm using your name because you are already a character whose name can be used as a trademark because of that goodwill and reputation that you've created as an individual.
Okay. Thank you, Sylvans. I'm not sure whether you answered this question about...
There was one, a child, if a child has invented, I've remembered. I think whether an invention has come from a child or an adult does not matter, because what will happen here is that there are other laws, particularly law of contracts, which will talk about if this child is at the age of owning a property per se. And if not, then the next of kin is the one who can apply for this protection on behalf of the child. Actually, this question is very important in the sense that I've always shared this. When somebody, for example, a child has been given a panga or a djembe to go and slash or till some land for some payment, then that one definitely will be referred to as child labor. But when the same person of that age, minor age, recites a poem and ends up getting some huge kind of reward in terms of that, would it still be called a child? Will it still be referred to as child labor? It's very interesting that when it comes to intellectual property, there is no boundary as of this being child labor and this not being. The reason why I came up with this, I reflected on what happened in Thika when the head of state was there at a function, and a 6-year-old young girl recited a poem there. I don't know. What I know is that she ended up being nicknamed the president's daughter. She recited a poem, and out of that poem, a 2-bedroom house came up for the family. This is one transition from when these people were living in a shanty. I think it was somewhere that was not very good. to moving to a 2-bedroom house, courtesy the poem that this young girl recited. So this bedroom worth of a house came as a result of the intellect of that young girl, a minor. What would be said about that? Is there a conflict between what we describe as child labor and what now comes up in this era of information age that we are talking about, where intangible can now be a source of income much more than material? So we need to look at that, because this house was as a result of what she did, and therefore the monetary aspect of that could be related to what she did as a minor.
Yes.
Child labor or not?
Yeah, very delicate.
Very
Balancing
so
act there.
I think this one is interesting, is that the person who is eligible to own a property in terms of age will be doing on behalf of the child. But it is true that even a child can invent, because with intellectual property, there's no boundary in terms of age.
Okay.
Yeah, there is one question that Helen, you wanted.
Yeah, I wasn't sure whether this question on if software is not patentable, what element of software can be protected, whether that was answered. And there's a question here, what is the shortest time a patent has been granted in Kenya? But I think that question has been answered somewhere in the chat by Joseph Hamisi.
Okay.
And there's a question that has come in, which I think you answered. What happens to images of media personalities when promoting advertising, broadcasting programs? What's the monetary value? This has been answered. Yes, there was a question from Alan. Alan had asked that you repeat the names of the international conventions and treaties you had mentioned earlier.
I repeat the names.
Yes, please.
Okay, I mentioned, there are many, but I mentioned 3. The first one, I mentioned Paris Convention on the Protection of Industrial Property of 1883. I know that one I didn't add, but I'm adding now. I also talked about Berne Convention for the Protection of Literary and Artistic Works of 1886. And I spoke about WTO trade-related aspects of intellectual property rights, that's TRIPS, of 1995. I know there are so many others, but if you'd want to get many others that Kenya is member, then I think he can go to KIPI website. You'll be able to get all those treaties that Kenya is a member, and even I think Kenya Copyright Board website will also provide those that are on copyright.
Okay. All right. Thank you very, very much. We have come to the end of our 2-hour webinar today. And as I always say, even for me, it's a learning session. So I like to sit back with an open mind and wait to, learn at the feet of some of the experts who very willingly agreed to work with us on these sessions. And for Sylvans, he's basically a friend of USIU and a friend of Helen, not just USIU. So I'm very, very grateful for him having accepted to participate. A very big thank you to the participants for the insightful questions asked, very interactive. I think this is the model we'll use for all the other webinars. And to my co-facilitators and moderators, thank you very, very much. We shall see you on the 24th of June for the Entertainment Law and Copyright webinar. But for those who registered, we shall send you a recording of today's session. On behalf of USIU Africa, thank you very much for attending this webinar today. Salome, Susan, Sylvans, do you have anything to say in closing?
Just to thank everyone for listening. I think it has been a very interactive session, and would like to see many more of this if USIU Africa would organize. As you can see, the questions have indicated that probably even if we've done it for 2 hours, still it was not enough to cover the whole aspect of intellectual property.
Yes.
And I think that one is something that we need to pursue further. Thank you very much.
Yes.
Yeah.
Yeah.
I think on my part, I will place a poll so that we can allow our participants to rate and give us feedback. But other than that, thank you, Helen, Sylvans, and Susan, for giving me the opportunity to be a co-moderator, and also thank you to the participants for the mind-provoking questions. Thank you.
Yeah, and just the same sentiment, very appreciative of this opportunity. Thank you so much to Sylvans, Helen, and Salome. It's been a great session, and yeah, looking forward to more.